Internet or cyberspace, which is indispensable in modern days. It is our go-to research tool. Before purchasing or selling, we all go to research online, and even enterprises, they market, they sell, they purchase, which propel a domain name to become a valuable corporate asset. In 2020, Anuradha Bhasin versus Union of India, Ghulam Nabi Azad versus Union of India, the Honorable Supreme Court declared that the internet as a mode of business is our fundamental right. That is Article 19, subclause G, the right to carry on any business, profession, trade is also cover internet. But however, it should be in consonance, that is the restriction upon it should be in conformity with article 19 clause 6. This brings us to domain name. Every internet has a web page. Web page is an address, URL, which in beginning was a intrinsic number. Later on, due to advancement of technology, this transformed into domain name, which is user friendly. Domain name is an online identity of a person excuse me, or enterprise. What happened is that this domain name is a mode, and it started to function as a business enterprises. Example, e-commerce, they through internet as a mode they function, which is becoming more and more we depend on it, and that is propelling a domain name to becoming such a vulnerable for offense. For an example, to cover that, trademark. What is trademark? Is a sign which distinguish one goods or service from another. In Satyam Infoway versus Union of India, the Honorable Court held that we don't have any explicit law in India which cover domain name. So we have to take it from trademark. As I have already defined what is trademark. In beginning, this domain name started as an address for a communication, but later on it became a mode of enabler of a commerce, e-commerce, where the consumer will identify the trademark and they will relate it to domain name, and they will go and research, they purchase, they sell. The enterprise, more and more they started to market their product or goods online, and it possesses all the characteristics of a trademark, and it is accepted and recognized as a section 2Z service of Trademark Act. The Honorable Supreme Court also held that it qualifies for passing off. Why? Because if in case someone else, some other registrant registered the domain name of a well-known trademark and it dilute, then that will create a confusion among consumer, and they will go and find something else, not the trademark that they have already understood from the sign, and it will cause delusion of the already the repository of a goodwill reputation of the well-known trademark, and it will dilute the trademark. This is the reason it also qualify for passing off. This domain is now started to play such a pivotal role, and it is also becoming prey for crime. For an example, cyber squatter. What they do is that they will go and register this well-known trademark with the whole sole purpose of extorting money from the trademark holder, because there is a loophole that they registered first come first. They don't have to take any prior permission from any authority for the proprietorship. And they are warehousing the domain name with a malefied intention to extort money from the trademark holder. In Mineral Aqua versus Promote Wars, the Honorable High Court held that as we have already accepted passing off an infringement for domain name, does it also get protection how trademark does? It held that if there is a credible explanation why the registrant is registering the domain name, then it can be. Otherwise, this will come under the classic example of cyber squatters, because Bisleri is already a well-known trademark, and everyone will assume that their trademark will have the similar domain name, and they will go, and if it is not so, then they may lose their customer. This is the reason why these cyber squatters, they take advantage of this loophole, and they will register with the malefied intention, and they will register. Later on, they extort money. If there's a credible explanation, then it's all right. If not, and this is also one of the guidelines of UDRM, that is Uniform Domain Name. And this is the first case in India where we invoke UDRM guidelines. That if in case anyone is registering the domain name with the malefied intention, then this can be a ground for rejecting the registration. So already domain name is accepted, and now they are eligible for infringement and passing off. What are the mechanism that we have? In international level, we have Internet Cooperation for Assigned Name and Numbers and World Intellectual Property Organization. They regulate and set guidelines for domain name in international. In India, we have our own .in, that is India Dispute Resolution Policy. Although we are not subscribed to UDRM, but however our guidelines also set according to their guidelines. For example, these administrative proceedings, they can even though there is a administrative proceeding going on, they can even file a suit. It will not forbid them from filing suit. And even the remedies are that they can transfer, the administrative arbitrators can transfer or cancel the domain name, but they don't have the authority to provide compensation or reward. In Beiersdorf AG versus Ajay Sukhwani, the Honorable High Court decided whether the decision of WIPO will amounted to res judicata, that is section 9 of CPC. The Honorable Delhi High Court decided that the decision will not be amount to res judicata. Why? Because the arbitrator, their qualification is not judge nor do judicial officer. Their only qualification is that they need to have knowledge, expertise of computer or law. And moreover, according to section 134 of trademark, it is clearly written that only district judge has the authority to decide infringement and passing off. So that is all. Thank you.